Well, it's midday right here in Lagos, Nigeria. Welcome to Lunchtime Politics. We bring you up to speed with the big happenings in politics and the polity, and there's a story we're tracking at the moment. Let's begin with the headlines. I can tell you that all eyes are on the Supreme Court at the moment. The Supreme Court has reserved judgment in PDP's appeal against the judgment nullifying its convention of the Turaki-led NWC, as we await the decision concerning the ADC. And President Bola Tinubu fires Wale Edun as finance minister, promotes Taiwo Oyedele as minister, as well as the Minister of Housing and Urban Development has also been sent home, Mr. Ahmed Dangiwa, in a cabinet reshuffle considered minor by the presidency. Before we get started with what we are tracking at the Supreme Court, let's tell you what had played out not too long ago, and that has to do with the president approving a minor reshuffle of the Federal Executive Council as he dropped the Minister of Finance and Coordinating Minister of the Economy, Olawale Edun, and the Minister of Housing and Urban Development, Ahmed Dangiwa, from their cabinet positions. According to a memo by the Secretary to the Government of the Federation, Mr. George Akume, Mr. Edun has been directed to hand over to Mr. Taiwo Oyedele, who is now to take over as Minister of Finance and Coordinating Minister of the Economy. Meanwhile, Mr. Mutaka Rabe Dama has been named as a ministerial nominee and minister designate for the Housing and Urban Development Ministry. The memo also directed Mr. Dangiwa to hand over to the Minister of State in the ministry. Explaining the decision, Senator Akume says the change is aimed at improving coordination and strengthening delivery across key sectors of the economy under the renewed hope agenda of President Bola Tinubu. Now, tomorrow, the window for party primaries will be open and it will close on May the 30th. I try to remind you, so you're familiar, for those who are not familiar with political season, it is when you have to decide as a party who is your candidate across all elective positions for those that will be participating in the 2027 elections. But we can tell you what's playing out at the Supreme Court. The opposition have been in one crisis or the other that has to do with leadership tussle, and one of which is the ADC and the PDP at the Supreme Court. But we have news coming in from the Supreme Court, at least for the PDP, where it has reserved its judgment in the appeal filed by the Turaki-led group of the PDP seeking to upturn the judgment of the Court of Appeal which nullified the conduct of parties convention held last year in Ibadan. A 5-member panel of the Apex Court announced on Wednesday that its judgment will be delivered on the day to be communicated to all parties in the appeal. Justice Garba Mohammed, who led the 5-member panel, made the announcement shortly after the lawyers representing the parties in the appeal adopted their processes as brief of their arguments for and against the appeal. The appeal was filed by the Turaki-led group's national executive of the party, who emerged from the Ibadan convention last year, November, that approached the court to challenge the judgment of the Court of Appeal, which had nullified the convention from being held in disobedience to court order. So from the two we are monitoring, ADC, PDP, we can tell you that is as far as this PDP's case is concerned. So the date where the Supreme Court, I'm sure, is going to be quite short very quickly because of it has to be granted accelerated hearing. Time is of the essence, we'll get to know. Is that what is going to happen with the ADC as well? Well, I'm working my device to make sure that our correspondent, who is right in the court, will be able to give us updates. When it happens for the ADC, I'll let you know. But before that, let me bring in, I have two-part conversation today, and they're all the opposition. One is ADC, the other is the Labour Party. But let's get started with the ADC. Ladan Salihu, who is a chieftain of the ADC, joins us virtually. Mr. Salihu, thank you so much for coming through, sir.
Thank you for having me, my brother.
Are you anxious? Are you concerned? Are you worried? Can you describe your emotion as we speak? I know this may sound personal, but let's start on that note.
I am very upbeat, Geoffrey. I am optimistic, and we look forward to, what we expect and consider will be ADC getting the judgment today. basically because I think the issue has been so much discussed, so much debated, so much in the public domain that the legal term status quo antebellum has become almost a swan song on the lips of Nigerians, especially those of us in politics. And we look at the issues. We believe in the majesty of the judicial process and the supremacy of the law that guides the conduct of both, the practice and processes of politics and democracy. And, looking at all that has happened leading to today, the rank and file of our party, the chairman, the national, executive committee, the working committee, if you like, and, leaders at various strata of the party can't wait to have this judgment, because we believe that having the judgment will clear the path for our, our activities going forward. And so there is a lot of anxiety. I wouldn't be the one to hide that. There is a lot of worry and concern. There's a lot of tension, but that has been eclipsed, or is eclipsed, by the optimism and the positive thinking that we have, and the positive disposition on the outcome of it all, because we believe that we are on the right path, because we believe that we've done everything to convince the court and the court of public opinion that ADC has more than a strong case. So let's wait and see how the day will issues will unfold. And like I said at the beginning, we are not only optimistic, but we are looking forward to what will be a judgment in the favor of the ADC. And the reasons, Geoffrey, if I may just extend the conversation a bit, are clear. When you look at our convention, and then an attempt by the other side.
Mr. Salihu?
To even call a pack of cards.
Mr. Salihu, I don't know, the network is not allowing us to get a full value of what you're saying. But if you can hear me, maybe in addition to what you're saying, if you can hear me in addition to what you're saying, I don't know what's going on with the network. It's been not too good to all of us this period. I don't know what's happening. We're actually just working devices. Yeah, just hold on, sir. Now that we have you, let me throw in my next question. Maybe you can add it to your thought. Just like you, as journalists as well, we are working our devices, those of us not in the courtroom, following up what our reporter will be sending to us to what exactly with this case will be. But the judex, as arbiter adjudicating this case, we can't go to the substantive issue. In fact, the substantive issue is actually at the trial court, which is the leadership issue. This is just an appeal, interlocutory in this sense. So without going to the substantive issue and maybe not digging into what strategy you have next, there are only two things that can come out of the Supreme Court today, except the reserve judgment. If judgment is today, only two things will happen. One of the two is either the court will say the appeal court was right to tell you to go back to the trial court and show cause why the interlocutory injunction should not be granted, maybe stopping David Mark and co from parading themselves as leaders of the party pending the substantive suit that was via originating summons where ancillary and declarative reliefs were sought. That is one angle. Or the court to say, no, David Mark and co are right to say you did not even have a premise to entertain this case based on extant law. So this case is, this appeal is upheld and they don't have any reason to be in court. Let them resolve their case outside the court. I've given you two scenarios. Let's look at the worst that can happen. What do you do in case of any of these two scenarios happen? Mr. Salihu, you can hear me.
First of all, let me be very honest with you. For now, we don't want to extend or drag the conversation to a point where we bounce on the limits of, being sub judice. But, I had a conversation with a senior lawyer who told me that when the case was first mentioned at the lower courts, that he was appalled and, he was shocked that, the judge in the lower court even took the decision he made that he ought not to have even entertained, the case because his submission, the submissions were both lame and preposterous, but that's for lawyers to discuss. I will go with your second option because, the law is the law, and the law should always be seen to be respected. We in the ADC, it's not about ADC per se, it's about the Nigerian public. The courts did not, for instance, direct INEC to stop the ADC from going about, its own operational activities as far as the leadership issue was concerned. INEC on its own, jumped the gun and decided to arrogate to itself powers it does not have. And so the worst case scenario is not on our side. The worst case scenario is on the side that went to court first. It is the onus is on them to show reason why they should be listened to. I think the ADC has proved beyond any iota of doubt through our lawyers that we don't only have a strong case, but we have a case that will, at the end of it, all things being equal, will come out. We as a party can only do.
Oh dear, Mr. Salihu, I don't know what's going on with the network, but we wish we can just conclude this conversation in as much as we can without being distorted. But can you hear me, sir? Oh dear. Oh boy. Okay. Well, Mr. Salihu, if we can get you back, we'll definitely get your last thought on this, because I wanted your voice, you to lace your voice on another national issue as far as the nation of Nigeria is concerned, besides the case in court, which we cannot speak to all the elements. But we must thank you, Mr. Salihu. But if we can get you back, we'll be more than glad. Mr. Salihu, I understand you're back. I just have about a minute more for you to land on your thought. My apologies, the network has not been supportive.
It's the epileptic nature of the of the system we all have to contend with. But like I said, Geoffrey, we believe that the two things will play out today. Either the court, after listening to the judgment, after listening to after all the proceedings, may decide that they can give a ruling today, or they may ask for all the parties to come back at a later date for a ruling, or they can give us a few hours and say, you come back for a ruling. It's all in the hands of the judges. It's no longer in our hands. So we wait and see. It's a waiting game that is full of anxiety, full of tension, full of concern. But like I said at the beginning, we are very positive, we are very upbeat, and we are more than hopeful that judgment will be, in our favor.
Thank you, sir. Landa and Salihu, ADC Chieftain, thank you for always coming through, no matter when we call. Thank you, sir. I appreciate it. Oh dear. Let's move on now to where we can tell you that a three-member panel of the Court of Appeal Abuja has dismissed the appeal filed by Julius Abure challenging the leadership of the Labour Party. Justice Peter Lifo of the Federal High Court had on January 21 reaffirmed the earlier judgment of the Supreme Court that removed Abure as the national chairman of the Labour Party and directed the Independent National Electoral Commission (INEC) to recognize Senator Nenadi Usman as the legitimate leader of the party to the exclusion of all others. Mr. Abure approached the Court of Appeal seeking to overturn that judgment of the lower court. However, the lead judgment delivered by Justice Oyejojo Oyemui, the appellate court, affirmed the decision of the Federal High Court. In the meantime, Mr. Abure has rejected the appeal ruling on his leadership dispute, maintaining that issues relating to party leadership remain internal matters. Let's bring in our guest. Kennedy Hanotu is the national youth leader of the Labour Party of the Abure Group. Mr. Hanotu, thank you so much for coming on the program.
Thank you. Good afternoon, Nigerians.
Trial courts and now the appeal court that has upheld the position of the trial court.
Because there are high level of manipulation which is very clear to anyone that has been following the case since it started. If you can remember, the matter of Labour Party has gone all the way to the Supreme Court before, and suddenly November last year, Mrs. Nenadi went to court and said that he's interpreting the Supreme Court judgment at the Federal High Court. And the High Court judge, Peter Lifo, like you mentioned, looked at it and said that he had the decision to interpret the Supreme Court judgment and affirmed that the Supreme Court have clearly said that the tenure of Abure had elapsed. And if you look at the Supreme Court judgment, to the betterment of Nigerians, there is no paragraph, there is no clause, there is no sentence, there is no, synonymous word there that have reflected that Supreme Court have expressly said that Barrister Julius Abure had been sacked. And this brings us to the integrity of the judiciary. In one way, the judiciary is saying that the issues and matters of political parties are entirely their internal affairs. On the other hand, the same judiciary is now saying that yes, the court can interpret where leadership there is a vacuum. It is the institution that will acknowledge that there is a vacuum. It is still the institution that will say there is no vacuum. And the Labour Party as an institution went to that Federal High Court and stated clearly that there was no vacuum in the party, given the fact that the party have had a very good convention at Nnewi in Anambra State on 27th March 2024, that there is no vacuum because Abure being the national chairman, it was acknowledged by INEC, by every authority, that there was a chairman, there is a chairman in the party from 2021 when Abure emerged after the death of our former national chairman till 2023 after our presidential election. The NEC met, INEC was there, where they extended the tenure of Abure for 1 year. And within that 1 year, Abure was mandated to conduct a national convention on 3rd of December 2023. Abure gave a notice. This notice was supposed to be 21 days, but Abure gave over 3 months notice to INEC that the party will be holding its national convention on 27th of March 2024. So, and the party held that convention. And today, the court is telling us there was a vacuum, and they are not even listening to the party's agitation, that there has never been any vacuum. Common sense should even let you know that if you are a governor, you know that the election is coming in 2027, you have to start putting things in place, preparing for your campaign. The same thing applies to party leadership. Abure knew that the convention, the party leadership will expire in June 2024. And Abure wrote INEC December 2023 and held the convention March 2024. So where did the vacuum come from? So for me, as a young man that have been a student of politics, it's very, very discouraging, given the fact that I've been in this party for the past 10 years. I've never seen this high level of desperation by individuals that just joined us in 2023. and they insisted that every other person in the party must go, that they are ready to take over the party. And indeed,
just a moment. At the end of the day, the appeal court has made a decision, and the right thing to do has been done now to appeal and head to the Supreme Court as to what the Supreme Court, which gave that judgment, actually meant, whether it was an obiter or a consequential order of court. Because I remember that particular judgment. I haven't seen the CTC of this particular Court of Appeal decision, so I may not be able to speak on good authority to it until we see the reasoning of their Lord Justices. But let's talk about something a bit more holistic. There are plethora of judgment from the apex court. I'm not even talking about the trial court. The apex court, from the Abure case to that people at one point was cited from other cases. But I remember vividly the case of Rivers State when those defection issues happened. A contributory judgment, albeit controversial, that came from one of their Lord Justices, and clearly stating how that parties' internal issues should remain with the party, and the emphasis was on membership and leadership. The only locus classicals we have is the Abegunde case and the Ondo State House of Assembly, because the argument is what constitutes disagreement and what constitutes division. And then now there's an extant law, Section 83, subsection 5 and 6. We keep quoting this law that says no court in Nigeria shall entertain issues around the issues of internal party dispute. But it also envisaged that there will be elements that will also approach the court. It said, no problem. When they come and present their cases before this court, in subsection 5, say, look, do not give any injunctive order, whether ex parte, interlocutory, decide everything together. As a matter of fact, the law says the lawyer who brought the case, the litigant who instituted that case and brought it before the judge, because we've said don't come here, they will pay maybe minimum of 10 million. It's in the law. Now, we still see political parties heading to court, including yours. It says only one thing, that parties are unable to manage their own internal affairs. So what do you want the courts to do if you can't put your own house in order?
Mr. Geoffrey, thank you so much for the very sound legal analysis that you have provided. Of course, and that is even where we are standing on, and that is why we've always gone to court. We are not the one that instituted this matter. Since after the 2023 general election that we had a lot of people come into the party, a lot of people come in with misfeelings, a lot of people came in with the thought that these guys are not supposed to be in party leadership. Of course, they have been the one flouting the court. They went all the way to Supreme Court. Supreme Court told them that it's an internal affair of political party. Go inside their house and settle. But it's worrisome that after the Supreme Court judgment, with all the noises they made that the Supreme Court have sacked Abure, none of them were able to institute contempt of court proceeding on Abure, meaning that they are fully aware that truly is an internal affair of political party. But now they went to court and deceived let me not say deceive, because I think it's manipulation, because the judge of the Federal High Court, Salihu, knew expressly what the Supreme Court said, because he must have read that judgment before he now gave a consequential order, which this section of the Constitution you mentioned have always been against, that no court should give such a consequential order. And without giving fair hearing to the party came to join. In fact, they secretly want to institute that matter. The party got hint of it and came to join. The Labour Party joined, Barrister Julius Abure joined, and they didn't listen to any of them. Depending why the party was shouting that we don't have any vacuum in the party. There is no vacuum in leadership. We have done our convention. Till even this last judgment of yesterday, the appeal court justices have failed to acknowledge that the party have been shouting that they have done. In all their assessment, they've not looked at what the party did on 27th of March 2024. The court have refused to look at that. And that's to show you that there is high level of manipulation and impunity in our judiciary. But nevertheless,
I wouldn't want to. Yes, Mr. Anos, I wouldn't want to impugn on the integrity or the of the judiciary. So we don't paint all of them in one brush. But I'll go back to my point. Yes, I'm going to go back so that we don't We don't disparage the institution for institutional preservation. We know there are challenges. But in closing, let's talk about something. And I want you to speak to this as a politician, honestly. Because everybody's grandstanding. If you go to the ADC, everybody's grandstanding on who is right and who is wrong. PDP, they are grandstanding. So today is victory for Abure, tomorrow is victory for Nanadi. In PDP, today is victory for Yeson Wike, tomorrow is victory for Turaki. In ADC, today is victory for Senator David Mark, tomorrow is victory for Nafi Ba. So what do you think in terms of legislation that can be proposed to give a structure such that within political parties, by the force of law, there can be a final arbiter when it comes to membership and leadership? Because even disciplinary committee, NEC, National Convention, BOT, all cannot solve party problem. What else has to be done? Because the court did not invite you, you approached the court, right? Yes. So in 1 minute, if you can answer that question.
Mr. Geoffrey, thank you so much. I'm not trying to impede on the immunity of this thing of institutions. Of course, I'm a strong believer in institutional sustainability and development in Nigeria. However, it has not been uhuru. It has not been working, and we can all see it. What PDP has experienced today is similar to what Labour Party has experienced. PDP case, Wike, for me, is right. He has been in the party for the past 23 years, and one man will always come every 4 years to drag the party presidential ticket against the people that have been members of the party. And Wike said, no, this cannot happen. It can be, people must be members of party and stay there for 5 years, 10 years before they demand to even represent the party. Look at what happened in Labour Party. We have produced about 38 members of House of Representatives. Today, except those few of them from other states, they've all left because they didn't take time to stay in the party. So if there will be any legislation, which I doubt, because the court have said that it's an immune, the political parties are immune, they are on their own, you know. So if there could be a legislation, which I think this Electoral Act amendment really came close to doing by saying that parties must submit membership register of members even before primaries. These are areas, I think, approaches to making sure that membership of political party are sacrosanct. And of course, there is no way you have a political party, somebody that joined the political party under 1 year, assuming the topmost position of leadership in that political institution. Even in this your channel TV or any banking sector, you can't have an employee today and tomorrow is assuming the office of the MD. It's impunity. It's not good. It's unacceptable. And that is why I'm confused and concerned that the judiciary is not even helping Nigerians.
Okay, Mr. Anusu, it's an ongoing conversation. We're all stakeholders in the Project Nigeria, which is why we are asking these questions as journalists, and we want a robust, because what all of you in the opposition are doing now, you're denying Nigeria the opportunity to hear alternative ideas. That's what's happening.
Not opposition political parties, but opposition gladiators. They are the one causing this problem.
You're all opposition. You're all opposition. I don't want to separate anybody.
The gladiators are the players.
I will put all of you inside one box for now. Forgive me, because you're a divided house. Kennedy Ahanotu, National Youth Leader of the Labour Party of the Abure Group. Boy, it's difficult to introduce you guys. Every day I say this. Thank you. I appreciate it. Thank you. Thank you. And that's it on the program. And we're keeping our eyes on the courts. The first judgment, the first decision has come. The second is expected, and we'll get to hear that later on in our subsequent bulletins. Stay with channels. We'll bring you up to speed on that. I'm Jeffrey Uzama. Thank you for watching. You've been served on Lunchtime Politics. Bye-bye.